Welcome to The Explainer. Today, we're diving straight into the truly wild 2003 Constitutional Court of South Africa case of Arthur Gcali. It is a fascinating look at exactly what happens when a citizen decides, they know better than the entire legal system. We're talking about a guy who ignored the rules and attempted what I like to call the ultimate legal shortcut, trying to march straight up to the highest court in the land. Let's get into it. To really wrap our heads around the absolute chaos we're about to explore, you just have to hear this striking assessment from the Constitutional Court itself. They described our protagonist as having an unfortunate inclination to follow his own head and to ignore or seek to circumvent court orders. I mean, that single sentence perfectly captures Arthur Gcali's character and, honestly, the sheer procedural mess he managed to create for himself. So here's our roadmap for today's explainer. 1. The ultimate legal shortcut. 2. A history of contempt. 3. The 3 high court hearings. 4. What is direct access? 5. The court's final verdict. And finally, 6. Why procedure matters. Section 1. The ultimate legal shortcut. A lay litigant versus the system. The sheer scale of what Arthur Gcali was trying to pull off here was, well, massive. He was the former town clerk of the Butterworth municipality, and back in 1999, he launched this colossal lawsuit for wrongful dismissal and defamation. And look at who he was suing. We're talking the member of the Executive Council for Housing and Local Government, a former mayor, a local newspaper called the Daily Dispatch, plus various local municipalities. This was a highly complex damages action. But here's the kicker. After getting a little bit of initial help, Gcali decided to represent himself. So you have a layperson navigating incredibly deep, complex legal waters entirely on his own, taking on multiple well-funded respondents. And as we'll see, that quickly led to some serious procedural hurdles. Section 2. A history of contempt. Insulting the bench. Now, legal documents obviously need to follow certain professional standards, but Gcali, who was probably getting pretty frustrated by the opposing lawyers poking holes in his poorly drafted claims, decided to turn his anger toward the judges themselves. He actually submitted affidavits to the High Court containing incredibly offensive remarks about the competence of the judges. We don't have the exact quotes in the source record, but the High Court characterized them as being so serious that they literally bordered on contempt of court. You simply cannot hurl insults at the bench in your official legal filings. By doing this, he completely derailed his own lawsuit before it even got off the ground. Section 3. The 3 high court hearings. A masterclass in what not to do. Over the course of a year, Gcali managed to dig himself into a massive legal hole. Let's look at the timeline. In September 2001, at what we'll call the first hearing, the judge ordered him to file an affidavit apologizing unreservedly for his insulting remarks. Did he? Nope. Instead, he filed a notice questioning the court's authority. So fast forward to November 2001, the second hearing, the judge had absolutely had enough and barred him from taking any further steps in the case until he purged his contempt. Then we get to September 2002, the third hearing. Because he was barred and still hadn't properly complied, the court straight up refused to hear him or his representative. The respondents successfully applied to have his entire claim set aside. And what was Gcali doing during all this? He literally just sat there in the courtroom, recording the proceedings, watching his entire case collapse. I really want to pause here and emphasize just how severe that November 2001 barring order was. The judge didn't just tell him to sit down and be quiet. He barred him from being heard at all. In fact, the judge even directed a copy of the judgment to the director of public prosecutions because the contempt was just that blatant. And yet, amazingly, the judge actually pleaded with Gcali. He advised him on the record that the matter was extremely complex and begged him to get proper legal representation before the costs ruined him. But Gcali, true to form, ignored this advice entirely. Section 4. What is direct access? The constitutional VIP pass. Okay, so Section 167, 6A of the Constitution allows a person to bring a matter directly to the Constitutional Court when it is in the interests of justice. This is what's known as direct access. It's essentially a legal VIP pass. It allows litigants to skip all the lower courts and jump straight to the apex court. But, as you might guess, it is strictly reserved for extremely special, urgent, or profoundly important constitutional circumstances. Normally, navigating the legal system is like climbing a ladder. If you lose or disagree with an order at Step 1, the High Court, you appeal to Step 2, the Supreme Court of Appeal. Only after that do you go to step 3, the constitutional court. Gcali was stuck at step 1 because, well, he insulted a judge and got himself barred. So instead of trying to fix step 1 or appealing to step 2, he tried to leapfrog all the way to step 3. He demanded the constitutional court step in as a court of first instance and just grant him all his damages right then and there. Section 5, the court's final verdict, the reality check. So how did the court respond? Well, the constitutional court doesn't just hand out direct access passes like candy. They use very rigorous criteria. They look for the interests of justice and exceptional circumstances. They check if there's an absence of factual disputes, mainly because apex courts don't hold trials to figure out who said what. They decide the law. They also want to see that issues have been properly chewed over by the lower courts first. Most importantly, it is highly undesirable for the constitutional court to be the first and only court to hear a matter. Unsurprisingly, Gcali's case failed on virtually every single one of these points. Gcali's logic had a pretty fatal flaw. His entire argument for direct access was basically, hey, I have no other remedy. I am barred from the high court, so I can't ask them for leave to appeal. Therefore, I absolutely must come directly to the constitutional court. But the court delivered a really sharp legal reality check. They pointed out that being barred from proceeding with your main case doesn't stop you from appealing the barring order itself. If he thought the barring order was wrong in law or fact, he should have just appealed that specific order to the Supreme Court of Appeal. Which brings us to this blunt, almost sigh-inducing assessment from the Constitutional Court. They wrote, "The truth of the matter is that the applicant, unfortunately for himself, does not comply with court orders and does not appeal them either." This brilliantly illustrates the ultimate irony of his situation. He was crying out that his constitutional right to a fair hearing was being infringed, all while actively refusing to use the very mechanisms the justice system provides to get a fair hearing. You just can't ignore the rules and then claim the game is rigged against you. Oh, and there was one more thing tucked away in his voluminous, repetitive papers. Gcali actually sneakily included a request for the Constitutional Court to appoint him a free lawyer to argue this application. The court's response? A very firm no. They noted that there is no express constitutional right to free legal representation in civil matters. While the court does sometimes appoint counsel if it's in the interests of justice, they refused here because the complexities of this case were entirely of his own making. The court then summarily dismissed his entire application based solely on his own faulty paperwork. Section 6. Why procedure matters. The rules of the game. So why do we care about a stubborn town clerk from 2003, and what are our key takeaways here? First, procedural rules are a ladder, not just red tape meant to annoy you. They exist to bring order to disputes. Second, if you try to skip the steps of that ladder, you will fall. You absolutely have to exhaust your normal appeals. Third, apex courts cannot be courts of first instance, especially for common law and procedural disputes. They rely on lower courts to resolve those messy factual arguments first. And finally, ignoring court orders does not magically create the exceptional circumstances required to get a constitutional VIP pass. I want to leave you with this final, provocative question to think about. Where is the line between ensuring access to justice for lay people who might not fully understand the system and enforcing the strict rules of the legal game? The courts really tried to be patient with Arthur Gcali. They gave him chances to amend, chances to apologize, and explicit advice to get a lawyer. But eventually the hammer had to fall. The justice system is open to everyone, for sure, but it only functions if everyone, lawyers and laypeople alike, agrees to respect its boundaries. Thanks for joining me on this explainer, and keep questioning the mechanics of the world around you.